Bruh, sis, you do not have a clothing trademark just because you printed your logo on a t-shirt. It's still a Hanes t-shirt with your logo on the front.
My faith rising. I'm crawling out the trenches, holding me. My life.
Hello, visionaries. Welcome back to my channel. My name is Maresa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. We're continuing on the trademark series, and today we're talking about 6 reasons why your federal trademark application may have been denied. No need to delay. Let's jump right into it. Number 1, there was a likelihood of confusion. A likelihood of confusion is probably one of the most common reasons why a trademark is denied. It means that your trademark has a likelihood of being confused with another already registered trademark. You can have a likelihood of confusion based on similarities in appearance, feel, meaning, sound, overall impression, trade channels, and how related your goods and services are to the other trademark. For example, you can have T-Marquee and T-Marquee. They look different, but when spoken aloud, they sound the same. That could be a likelihood of confusion. You can also have Lupo and Wolf, and while they look different and they sound different, they actually mean the same thing when translated into the same language. That can also cause a likelihood of confusion. Or let's take City Woman and City Girl. Technically different, but it gives the same overall impression. And that could also cause a likelihood of confusion. The USPTO uses 13 factors, known as the DuPont factors, to determine whether a likelihood of confusion exists. If you'd like to hear more about these 13 factors, let me know in the comments. I'd be happy to do an explainer video. But if you have ever received a refusal from the USPTO based on a likelihood of confusion, you can use these 13 factors and compare your trademark to the conflicting trademark and possibly overcome the refusal. Number 2, your mark was merely descriptive. The USPTO will classify your mark as merely descriptive if it's pretty generic and will generally be hard to enforce. I have a video on the strength of your trademark, and it further talks about descriptive marks, so you should check that video out. I'll link it above and in the description box below. But basically, if your trademark describes some type of feature, quality, aspect, or even ingredient of your trademark, it's probably going to be categorized as merely descriptive and lends itself to refusal from the USPTO. Number 3, your mark is deceptively misdescriptive. So this is one of the alternatives to the merely descriptive. While your mark may not be merely descriptive, it could be deceptively misdescriptive. This means that your mark misrepresents or falsely claims some type of quality, feature, aspect, or even ingredient of your mark. Let's just say there's a restaurant called the Juicy Crab. If you walk into the Juicy Crab and nothing on the menu has crab in it, that's a problem. That is known as deceptively misdescriptive. You can't just be lying to the people now. You will be denied. Number 4, primarily geographically descriptive or misdescriptive. Okay, that's a lot of words, I know. But what does that really mean? This is just like the last 2, but it's talking specifically about a geographical location. So for example, if you try to trademark Napa Valley wines and spirits, and your wines or spirits don't come from Napa Valley, you're going to be denied. Number 5, primarily merely a surname. The USPTO may refuse your trademark if it's just based on a last name. You often see this with restaurants like Giovanni's Italian Restaurant or Checkers Family Diner, something like that. Typically, those marks are going to be denied. And last but not least, ornamental use. So I see this all the time with people who think they have a clothing brand. Bruh, sis, you do not have a clothing trademark just because you printed your logo on a t-shirt. Your trademark must identify as a source of a good or a service. So you cannot take a Hanes t-shirt and throw your logo on the front and then think you can get a trademark in clothing and apparel. It's still a Hanes t-shirt with your logo on the front. And when someone buys that t-shirt, they're going to see Hanes in the tag, not your brand, not your logo. So if you're starting a clothing brand that you think you want to trademark, your logo or whatever the brand is needs to be in the t-shirt, on a pop hang tag or something similar, or needs to be in the same spot on each article of clothing, kind of like Ralph Lauren polo shirts. Now, if you do receive one of these refusals, you have an option to respond. You can try to convince the USPTO that they should still register your mark. If you are currently stuck in one of these refusals, known as an office action, feel free to schedule a consultation with Talbert Law Office. We'd be happy to see if we can help you. I'll leave our contact information in the description box below. Otherwise, that wraps up this video. I hope you found it to be helpful, and if you did, please give it a thumbs up. Let me know in the comments if you've ever had trouble trying to get your trademark approved, or let me know what other questions you might have. As you know, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.
I done made it this far.